Welcome. Thank you so much for joining us this morning at ATO Partners for our next breakfast briefing. My name is Carl Tuffy. I'm principal here in the litigation and insolvency team. And today we're talking about the current position of the Australian Taxation Office. We thought we'd do something a little bit different to our usual seminars, and that is why you'll see three lovely people sitting on stools next to me. We're planning on having a bit more of a discussion today about the issues that are going on. And that means that if other people want to weigh in on something we're talking about, we're quite happy for people to put up their hand and weigh in on the discussion that we're having or ask questions. I'll introduce you to our panel before I put some context on what we're talking about. Welcome to Olga Kosti from TaxAssure. She'll tell us a little bit more about what TaxAssure does as we go along. Nicole G, a senior associate in our litigation and insolvency team, and Tom Carroll, a lawyer in our litigation and insolvency team, who's feeling the pressure because he's recently done the ATO course, and the person who may have been teaching that course is sitting in the room today. So this is a bit of an exam for Tom, we've decided. We'll see how he goes. So just to put a bit of context on what we're talking about today, the ATO, Commissioner of Taxation and Deputy Commissioners have always been very, very active in recovering unpaid tax debt. But when COVID hit, uncharacteristically, it went very quiet. And to put some context into that, the ATO would, on average, initiate about 200 applications for winding up companies a month prior to COVID, about 2,500 applications per year. That's just corporate insolvency. That's not bankruptcy, and that's not the number of SAT demands or direct penalty notices. $26 billion in collectible debt is going to be collected, or people are going to feel the consequences, and that's what we're really here to discuss today. So perhaps, Olga, if I turn to you for a minute, before we start, do you want to maybe tell people a little bit about TaxAssure and the services that you provide?
Yeah, absolutely, thank you. And I think it's a $53 billion reportable.
Reportable, but is it collectible?
Yes, so if it's reportable and collectible now, that includes what's been lodged. So there's a whole heap more that hasn't been.
Yeah, I think my figures were as of October, so it's even worse.
So what we do is we're tax debt specialists. So the three owners of the firm, in our past lives, we were all commercial lawyers. And what we do now is we just help people with tax debt. So we help negotiate the debt, we help reduce the debt where possible, we stop legal action, and we get them back into a position of compliance. So sometimes the best way to describe it is what we're not. So we're not a law firm, we're not an accountancy firm, we're not liquidators, we're not funders, we just help people in relation to advice around tax debt, the negotiation of the debt, and getting you back on track and compliant in that particular space.
So I suppose the next question is, what have you noticed as of late?
So the ATO are back. that's the best way to describe it. They're back also in a way that I don't think we've seen for a long time. So our feeling and what we're seeing and what we're dealing with at the moment is not just immediately how they were pre-COVID, but probably stronger than that as well. Stronger, probably sort of a couple of years even prior to COVID. There are new debt teams. So we speak to a different area than your accountants might. So we deal with the debt teams all day, every day. So our guys are talking to them. They even often say, occasional weekend, they have a relationship with the different debt teams. They've been retrained. There's been a huge recruitment process. And a lot of if there are accountants watching or here, you will see the things that we were able to get through, or the payment arrangements or the concessions that were given in the last 2 years have completely naturally stopped. There has been a specific direction by the ATO in the media that they're back into active collection mode. They're back collecting. They are very specific in relation to the plans they will grant and the information they want in relation to what they will grant, and it is not enough to just say, I'm COVID affected. The way that the ATO look at things is very different to a normal commercial debtor. And so what we're seeing as well is if you had a pre-COVID debt, they don't necessarily take off the last 2 years. So I'm assuming everyone sitting here lived in Melbourne during COVID.
If you can call it living.
So it's like we lost 2 years of our life. Like, it's literally like 2 years evaporated. We didn't live. However, on paper, if these debts had occurred in 2019, they're now considered 3-year-old debts. So if we rewind back to 2 years ago, if you had a 3-year-old debt in which you never called the ATO, you never told them about it, you never told them what was going on in your circumstances, you never said I need help, you never said I haven't paid, that's how they're being treated now.
Yeah. And so I suppose it's important for people to understand that really tax debt is at 2 levels. It's obviously at the corporate level if you've got a company, but the ATO also has special powers to make some of that tax debt personally, make it personally liable for that debt. So in particular, we're talking about PAYG, superannuation and GST. And the way that they go about dealing with that is through directors' penalty notices. And perhaps seen things in the media recently where on certain estimates, and how good these estimates are, who knows, but some people say about 30,000, some people say about 50,000 warning letters have been sent out. And in fact, we don't know how many of those have actually turned into directors' penalty notices. Have you seen some of these?
Yeah. So a huge amount of them, and we've also seen warnings in relation to credit reporting as well. So I'm not sure whether you're going to touch on that too. So the ATO also now have certain powers that if a debt is more than 90 days old and it's more than 100,000, they can report that debt to a credit reporting agency. So warning letters went out in relation to both the credit reporting and the director penalty notices. What we're also seeing is director penalty notices being issued in relation to old debt. So companies that were wound up 3, 4, 5 years ago even, where the personal liability wasn't extinguished by the insolvency event, and now the ATO are chasing the directors for that personal liability.
So it's probably important for everyone here, and of course joining us online, to understand that there are 2 types of directors' penalty notices. There's your lockdown and your non-lockdown notice. And what's critical about these is how you have dealt with your tax obligations. So in particular, whether or not your lodgements are up to date. And we see this all the time in the insolvency game, and I'm sure Nicole and Tom have seen it in a lot of the matters we've worked on, where directors might come to us, or we're acting for insolvency practitioners who come to us, and lodgements haven't been done for years. And we're not just talking about income tax lodgements, we're talking about your BAS, we're talking about superannuation. And if you haven't lodged within the requisite period of time, the ATO can issue you with a lockdown director's penalty notice, which gives you one option: pay the debt. You're personally liable for it. So being on top of your tax obligations is really, really critical in all of this. But in terms of the non-lockdown DPN, Olga and I had a very interesting discussion about this yesterday. With the non-lockdown DPN, you do have an opportunity to avoid personal liability. And it used to be the case that you could do one of 3 things. It is now the case that you can do one of 3 things, but one of those things has changed. You can pay the debt to avoid liability. You can appoint an external administrator, so a liquidator or a voluntary administrator, and it was the case that you could enter into a payment arrangement. It is now the case that the notice says you can appoint a small business restructuring, which Tom will talk to us about, because it's something that doesn't happen very often. So the interesting question is, well, if you're entering into a payment arrangement with the ATO, can you still avoid personal liability? So perhaps before we throw it to Tom to tell us about this new little option in there, Olga, what's your view on that?
So my view is, and I understand it might be slightly controversial, is that it's a technical distinction, and my background was I was a commercial litigator for a long time. So I think it's a technical distinction, and I understand that there's a judgment, and I understand that if it was brought before a court, that the ruling may be that they're the only ways to distinguish that personal liability. However, in practice, even if it's a lockdown DPN, there are ways to avoid further action. So we can still come in and organise and negotiate with the ATO a payment arrangement. Now, by putting that in place, in practice, that will stop further recovery action. So if you're put back into a position of compliance, which is what we do all the time, by being in a position of compliance will prevent the ATO from then taking the next steps on the DPN. And I'll leave you guys to talk about what those next follow-on steps are from a DPN and the recovery personally and the consequences of a DPN. But even with the new judgment, you can still stop the recovery action and stop those next steps by being in a position of compliance, engaging with the ATO and getting a relevant payment plan. So even though I think it is a very technical distinction and that there's been so much commentary going around after this judgment and what people are saying, I personally don't believe that the only way is to stop further recovery action, payment in full or an event of insolvency. The ATO also have internal policies that if you are in a position of compliance, and a position of compliance includes a compliant payment plan. So if you default on your payment plan, you're no longer in a position of compliance. But if you're sticking to your payment plan that's been negotiated and agreed upon, the ATO consider that a position of compliance and they will not take further recovery action on either a lockdown DPN or a usual DPN. But I suppose the caveat over that is as soon as you default and you're no longer in a position of compliance because you've defaulted on your payment plan, they can then take action, especially if it's a lockdown. But I don't think in practice it has completely changed the landscape.
I think you touched on the ATO policy. Nicole, we were talking yesterday, I think, about the stronger action policy that the ATO has. Do you want to talk about that a little bit?
Yeah, sure. So there are a number of different actions the ATO can take if they, these initial steps aren't followed and you aren't in a position of compliance. One of them is a garnishee notice. Some people might not know what that is, so it's where the ATO can essentially do a deal with people who would otherwise pay you, so debtors, or if you're to receive monies or something like that, and garnishee will redirect those funds to them. So that's one option. But I guess what I was going to talk more about is statutory demands and winding ups, and that's a very real thing that can occur if you don't pay your DPNs or your debt. So after the pandemic, the statutory minimum for a statutory demand was doubled. So for a company, it used to be 2,000, but it's now 4,000, giving companies a little bit of breathing room. Just to explain a little bit about what a statutory demand is. Apologies to liquidators and practitioners who already know the basics, but a statutory demand is a demand for payment, and you have to pay the debt claimed within 21 days. It is in a prescribed form, so it's very technical in that it has to have specific warnings and certain details in it. But if you don't pay within that 21 days, it can be seen or used as a basis to wind you up and be seen as an act of insolvency. And something to note in relation to statutory demands is that the timeframes are strictly interpreted. So when they say 21 days, it's 21 days. And in terms of what options you have if you're serving a statutory demand, you can of course pay. That's one option. You can try and negotiate some payment plan. There's also the option of seeking to have it set aside by issuing proceedings in the court, and the basis on which you can set it aside include, for example, that there is a genuine dispute in relation to the debt, and of course if you don't pay, that's where we get to it's a basis for insolvency, and it can go on to an application for wind up of the company.
So with that set aside, one of the interesting things is that quite often people try and set aside a stat demand that's been issued by the Commissioner of Taxation on the basis that they're going through an objection process, for example, or they don't agree with the tax assessment that they've got. Unfortunately for them, that doesn't matter. Until, even if you've got a proceeding in the Administrative Appeals Tribunal or even one of the federal courts to challenge a tax debt, the law says it remains due and payable until that court or the AAT reissue an assessment. So even if you don't agree with the amount of tax, by the time you get to this stat demand stage, it's a bit too late. You're going to have to pay it and fight about it later. So just in terms of non-compliance, assuming someone didn't comply with the stat demand or didn't set it aside, can you just talk through the process of the application to wind up a company and what that means?
Sure. So if there is non-compliance, there can then be an application to have the company wound up and a liquidator appointed. That can be in the federal court, commonly for the ATO, or it can also be generally applications to wind up can be made in the Supreme Court. And in terms of what options a company then faces is you can seek to have, you can oppose the application, and again, you can oppose it on the basis of a genuine dispute. You can say, in fact, despite not paying, we are solvent, and you can try to put on evidence about the solvency of the company. You can always, I think it is always an option to try and negotiate a payment plan or some sort of settlement. That's not uncommon for that to be a result in winding up proceedings. You know, it could be a case that the creditor says to the court, well, you know, we need an adjournment because we're negotiating a settlement. We expect to have settlement terms, and then the proceeding might be dismissed on that basis. So that's an option as well. But of course, if the opposition is unsuccessful or there is no payment made, what will happen generally is that the company will be wound up and liquidator appointed. I should say as well, sometimes there are arguments from another side, procedural arguments for opposition, you know, around things like service, or because the procedures are very strict in relation to statutory demands and winding up applications. There are some efforts sometimes to say, oh, I wasn't served with it, I didn't get it in time. But they are things that can quite easily be remedied.
And so just on that point, you've had an interesting case recently, not with the Commissioner, but it's relevant to this, about the registered office.
Yes.
So do you want to talk a bit about the importance of the registered office and making sure that your ASIC company search has the right address on it?
Sure. So in a recent case I had, we did have information that potentially directors had moved overseas, that things maybe weren't current. But of course, under the rules, and they are very strict, I keep saying this, but in this area, you really have to follow the rules. And what they do say in relation to an application for winding up is that you need to serve it on the registered office. There are a number of other ways you can, but it's either delivery to the registered office is one way, or post. And in our case, what happened was we did post it, but we received a return to sender. There was also an effort to deliver it to the registered office. But, you know, in these modern times, the registered office could be an office building, and it might say, for example, level 5 of whatever street it is. But when we got to the registered office, our person, he was actually a member of our staff, got there, the company's name was no longer there, and lot B on level 5 was not easily identifiable at all. You know, you turn up and you just see 4 office drawers with names, and you think, well, what am I going to do? Because the requirements say that we need to serve it at the registered office. In that case, we managed to identify which of those 4 offices was B, or where the company used to reside. My recommendation to the employee was that the requirements are that you deliver it to that premises, to that space. Unfortunately, in those circumstances, the company who was then a tenant on the premises was not happy for us to leave it there. They said, no, sorry, you can't leave it on our premises. And of course I said, well, you know, you never want to put anyone in a position where they can be in a hostile situation. So the next best thing was to put it in their mailbox. And you would think, well, you know, for a normal residential property, someone's mailbox is on the premises. It's, you know, at the front of the property. But in this case, the mailbox was in the lobby. So we did place it there. And the funny thing is, if you posted it, the envelope would go to the lobby mailbox. But anyway, the affidavits are sworn and all of that, and in fact, the court said that delivery to the mailbox by hand was not delivery to the premises. So they drew that very fine distinction. And they in fact said to us, whereas if you posted it,
Would have been fine.
it would have been fine. Which is a very strange thing. Of course, it would have ended up in the same place. But why the rules are different, we could say, is because when you post it, service is deemed by the action of your person putting it in the post box. It's then pretty much over to Australian Post, and after a certain number of days, which is 7 working days now, service is deemed. So we don't have to do that fact finding of where actually is the mailbox. Is it on the ground floor or is it on the premises? So that was logistically what happened, but then at court, the interesting thing too was that despite the fact that we did get a return to sender a number of times, the court said, well, you know, you were only required to serve it on the registered office, which was according to the ASIC search. You did that by post, and I'm satisfied that that was valid service, despite no response from the company. Bad luck, basically. So that is a reminder to companies that it is up to you to keep your registered address up to date.
And so obviously the court wound up this company
Yes.
in the end of all of that. But the key takeaway, as Nicole just said, is keep your registered address up to date, because that's where these applications are going to be delivered. That's where your stat demand is going to go. That's where all these things are going to happen. And even if you don't actually receive it, so long as these rules are complied with, you're at risk of your company being wound up. And the first time you might hear about it is when a liquidator contacts you and says, hey, I'm now in control of your company. And we've seen that happen many, many times. Just before we move on to, I guess, the powers of the liquidator and what that all means, Olga, have you seen cases where a creditor's petition or a petition to wind up a company has been issued, but you've still been able to negotiate a payment plan independent of the lawyers?
Yes, so we do in pre-COVID times, we do that all the time.
Yeah. So the fact of the application having been issued, your lawyers can negotiate with the other lawyers, but it doesn't mean that sometimes attempts to go to the ATO directly can't succeed.
But it's much easier, and you get a better payment plan and better terms are able to be negotiated before that happens. So even if there's a DPN, sometimes what will happen, we see, is both happen at the same time.
Yeah.
So the ATO will look at both the personal liability that's come across to the individual as well as potentially the company. So it's much better to deal with it prior. It's the same as if you're in a payment plan and you know you can't pay it and you think you're going to default or it's too onerous. We can still then go in and renegotiate before the default happens, or when before the payment can't be made, and get you better terms so that it doesn't actually default and then you don't end up in these situations.
So Nick, just very briefly before we move on to other options that Tom can talk about, why should people be worried about liquidators being appointed to a company, particularly if they're not doing it voluntarily?
Yes. Well, just by way of background, for people who don't know, apologies again to anyone who is a liquidator who's here or practitioners, but liquidators do essentially take over control of a company. They look into the affairs, they act in the best interests of creditors, they are independent and registered. But in terms of what their powers are and what they can do, they are many in that, you know, they will investigate, sell and liquidate assets. Another large part of their role is to investigate and report on affairs of the company, which includes, and this is where a lot of our work comes in, transactions which can be found to be void. And I think this is an area that could be of concern to many companies, because liquidators can look deep into the company's history and it's very wide-ranging in terms of what they can do. So there are preferences, unfair preferences, which can be, you know, just any payments made to suppliers or people who provide goods or services to the company in the 6 months before appointment. There are uncommercial transactions which can be turned around and there's a 2-year time frame, so that's 2 years from the appointment time, and they just, by way of example, could be sale of assets or businesses or property of the company for what can be seen to be not for the benefit of the company. Perhaps, for example, not at market value. Might think, oh look, I'm just doing the right thing, getting rid of assets, selling assets quickly to try and make ends meet. But if it's not for market value, those sorts of things can be turned around. Where it can really be worrying and issues when it can be to related entities and companies, you might see a bit of that. And again, companies might do it for whatever reason, or because, oh look, it's easy, we're going to try and turn things around. But, when they are related, the time frames in which liquidators can undo those transactions becomes longer again. And in some instances we can look at up to 10 years. So it's not the case that, if you think, oh look, we'll just sort of wing it or try and, do a quick sale to turn things around. It's obviously a good idea to get advice on these things and look at it from a point of view where, people can look at it later on and say, well, was it really for market value? Was it really in the best interest of creditors? And that's the focus that's then taken, not just, the health of the business, but its creditors. And that's a bit of a different outlook that is taken once a liquidator is appointed.
And one of the other things that a liquidator can do is look at insolvent trading. So
Yes.
when directors are deemed to have been trading a company whilst insolvent, liquidators are very fond of suing directors personally. Again, even if you leave aside what the ATO can do, the liquidator, him or herself, is able to eventually bankrupt you if they get a judgment against you. So again, there's an element of very real personal risks there, which people should be aware of. But there are other alternatives. So if we just take a step back and we go back to directors' penalty notices, we've spoken about payment arrangements. You can voluntarily appoint a liquidator to the company if you want to kill it, and you want to deal with the debt in that way, or protect yourself if it's a non-lockdown DPN. But there are some other options. So Tom, what are they?
So you've got, the newest, shiniest one that's been spruiked recently is the small business restructuring. So that's essentially, you appoint a small business, a restructuring practitioner, which is most of the time a registered liquidator, but there is a lower requirement because when this was announced, the government thought there'd be thousands of these. There hasn't yet, which I'll go into in a bit more detail shortly. But so essentially, that's an administration that leaves the hands of the company of the directors of the business. The idea behind it is it should be more streamlined and cheaper to come up with a plan to pay creditors and possibly restructure the business while getting it done in as quick as possible time. But there are some pretty onerous requirements to be able to actually use this. Now that is, you need to, I think it's $1 million, you need to have $1 million or less of creditors, and you need to be paid up to all your employee entitlements and also your tax liabilities. So find me a business that is looking to appoint a restructure, an insolvency practitioner that's paid up on all those things. And I haven't seen it. Apparently I've heard at least there's been at least 3, possibly more that have happened, but it's really rare, and it's going to be down to the sort of specific circumstances that the director would find their company in.
Sorry, Tom, just to jump in before we move on.
Yeah.
The ATO payments, just to correct it, doesn't mean that your payments need to be up to date. It just means your lodgements need to be up to date. Which again is quite rare.
But your super has to be. So your super has to be
sorry.
paid for your employees, but just your lodgements, not your tax obligation.
So I've already made a mistake in front of my teacher. So
It's all right.
I think that this, at least it's not like my dream. I am, in fact, wearing pants in this situation. Moving on. So
Let's move on.
I just worry about 5% of people who didn't get that job.
kind of show are you running, you guys?
We'll just get Andrew Clark to confirm whereabouts on the screen the camera is on the Zoom.
That's wrong.
We can see hands.
Okay, perfect. Not going to jail this time. All right, I'm going to stop making jokes and talk about voluntary administration.
So what is a voluntary administration?
So it's something you can do, before you want to go into a liquidation, where it's like an option to save the company. There's three outcomes that you can get from a voluntary administration. One is that it just ends up going into liquidation because you can't get any deals done. Two is it gets handed back to the directors after the administrators sort of looked at the affairs of the company and decided, actually, this is fine. I've never seen that happen. I don't know about you guys, but that's
Rare,
extremely rare. The third one, which is the one that you're really going for, is to get a deed of company arrangement done, or a DOCA. That's essentially just a deal that is voted on by the majority of your creditors to arrange the company's affairs, which includes how you're going to pay out debts to certain creditors and in installments, possibly for an amount of cents on the dollar that's acceptable to the creditors. That's going to get them a better return than the company just going straight into liquidation versus letting it go. But the biggest advantage, I think, of the voluntary administration, though, is that there's a moratorium on, with some exceptions, on secured creditors enforcing their security, which gives the business a bit of breathing space. One of the major exceptions is if the secured creditor has security over substantially all of the company's property. They've got a period of, I think it's 13 business days, in which to make a decision whether or not to enforce the security, after which they'll be treated like the rest of the secured creditors and they have to essentially wait out the administration period and see what happens with that DOCA vote. Along with that, you've got your lessors will be prevented from essentially evicting the business. So that position allows the administrator to kind of trade on the business and have that breathing space to see if they can actually get a deal done and get the business to trade on. More so than with the small business restructure, we don't have that moratorium protection. So even if you are able to take advantage of that, you're somehow able to stump up the cost to pay for it as well, you don't have the protection if a secured creditor wants to come along, enforce the security and start taking the business apart piecemeal they can, which is why I'm much more pro voluntary administration as your option rather than the small business restructure.
So if a deed of company arrangement gets up and you pay 10, 50 cents in the dollar or whatever it is to your creditors and you reach those deals, what happens after that DOCA is completed?
Completely, as in the terms have actually been complied with, yes. So the administrator will write to ASIC and say the deeds have been complied with and the company goes back into the hands of the directors.
And what's happened to all of the debts?
Free and clear, because the terms are essentially a deal to the creditors that will pay you X amount of your debts.
So apart from any secured creditors, it's a good way of cleaning up the company, basically, and that includes debts that are owed to the tax office. So the tax office is generally always a creditor when you do a VA invariably, so getting them on side is really important. But the VA is a really good option where you've got generally manageable levels of debt, or at least creditors that you can persuade to accept a deal and keep the company alive on the other side, and apart from your secured creditors, so people who have either a charge over your property, PPSR and things like that, which we don't really want to talk about today. It's a good way of just coming out the other end and being able to continue trading, no debts, your ATO debt is wiped, save for any personal liability that you might have as a result of a DPN already.
You can ask, this is probably a question for anyone, but what's your experience with how receptive the ATO are to a deed of company arrangement? Because obviously you need majority of creditors to vote in favour. They're obviously a significant creditor often in these situations.
So my experience has been that it very much depends on who at the ATO has picked up your file. And I'm sure Olga probably will say the same thing in dealing with the ATO. But in general terms, insolvency practitioners are very good at speaking to the ATO in these situations, and particularly if you've got a company that hasn't been through an insolvency event previously. You've got directors who haven't been through insolvency events previously as well, and there's an insolvency practitioner who, based on their investigations, can justify and make a recommendation to creditors that it's a good deal, and really justify that if the company were to go into liquidation, a liquidator is unlikely to do a better deal. The ATO is generally more receptive to accepting a debt company arrangement. Now, if you're offering something like 2 cents in the dollar, you generally, I think, get no. I think you've got to be at sort of at least, 10, 15 cents in the dollar to get their attention. And again, you need an insolvency practitioner who's able to say that's a far better deal than what you're going to get in a liquidation, because we don't have any preference payments, there's no transactions that we're going to be able to unwind, and we either do or don't have an insolvent trading claim. But even if we do have one, the director's got no assets, so we're just not going to recover anything. But if you do have a company that's been through this before, you're probably not going to get the support of the ATO. And if you've got a director who's been involved in this, an external administration, you're not going to get their support either.
And do you find that in other contexts of the ATO?
So I was just going to add in, the ATO are not like any other commercial creditor. They're not looking at the best deal. So people sometimes say to me, get me a deal. Or just, tell them that if they don't take 10 cents, then I'll go broke and they get nothing. It's not that they don't care, they're not a commercial creditor and they don't do deals. So they have legal practice requirements. They are very, very rule-bound and bureaucratic in the way things work. So we don't get involved with dockets, but it works in a very similar way. So everyone has their specific roles and teams, and it's not necessarily about how much money can we get in, it's about timeframes and it's about KPIs. So if something is on someone's desk, it's about getting it off their desk and into the next step. So the step might be to get them into a compliant arrangement that matches the legal practice requirements with what the ATO are allowed to accept and not allowed to accept. So our specific job is knowing those inside out and back to front, so I know what they can accept. And I know how to phrase my submissions and I know how to put our applications so they will just accept it. So it either needs to go from this particular person's desk to a compliance space, or it needs to go to this particular person's desk to legal. And that person sort of doesn't really care whether they want the money in, but the bigger issue is where does it then go? And so it's going to be the same thing again, like I said, we don't get involved with the dockers, but what can they accept within the legal practice requirements, within the guidelines. It's the same when we reduce debt, when we do applications to get rid of all the interest and penalties, is what are they able to take into consideration with those guidelines, rather than the guy at the pub told me that if you just ring them and tell them that I'll give them $100, they'll get rid of all of it, because don't they want my $100? They don't do deals like that.
And on that point, it's interesting you say that, because I had a case once where we had a docker for 70 cents in the dollar, and for insolvency practitioners that's pretty good, proposal. All of the creditors were on board with it. There were some related creditors, of course, but it's a pretty good commercial deal. The ATO said no. The docker was going to pass because of the support that other creditors were giving it. So they took the step of actually applying to the court to prevent the meeting from taking place. Now, we're not talking a multi-million-dollar company here either. We're talking about, it was a development company that did sort of 1 or 2 projects, probably less than $1 million, in turnover and things like that. So we're not talking a huge entity here. And the court ultimately accepted that the ATO had other interests than purely commercial interests.
Unpaid GST.
Yep.
So I'll get.
And they terminated that, they wouldn't allow the meeting to go ahead, and basically the company went into liquidation ultimately. So 70 cents of the dollar was just not acceptable to them.
So they put different flags on different files, and there are different risk ratings, and there's different areas in which you go to throughout the debt team. And again, this is our job, this is what we do day in, day out, this is how we know these things. Developers get different flags. And just before COVID, there was a huge campaign, and it's still actually going now. I've got two matters that we're running at the moment, that if you get a developer flag, and if you have unpaid GST that you receive that you haven't paid back as a developer, you get dealt with by a different team. And there are different requirements that then go on them because it's unpaid GST. The same thing is happening with super. So if you have been extremely COVID affected, but you have unpaid super, there are different flags and different things because of the unpaid super, because there's such a huge push for employee entitlements. And a new one we're now seeing is private wealth. So it's very difficult to find a definition at the moment as to who is classified into the private wealth debt team. But there are certain companies that have now been grouped, that have been dealt with different debt management teams because they're now being considered private wealth. So there's a lot of these things, and there's internal risk ratings as well. There's a lot of things that will affect behind the scenes where you might go, but this one got up for 30 cents a dollar, or this one's only got a 90 grand debt. This is an easy 3-year payment plan. If there are other factors that are put on the files, and that's why I think too, for us, it's not a cookie cutter approach. You have to evaluate every single different company, every single different situation, and know what you're dealing with. But yeah, developers and GST is a whole another box, and that's, I don't know that case, but that's why I asked the question, is it developer and GST, because it explains a lot.
Pre-pandemic, we would encounter accountants who would ring us up, liquidator, and so they'd ring us up and say, look, I've spoken to the ATO, and there's two, the debt's made up of two. There's the core debt, penalties and interest, and I can negotiate on the penalties and interest, but the core debt's got to be repaid, and so we do a deal on the penalties and interest, and then I've entered into a repayment program, and away they go. What I'm now hearing is that when they're speaking to the ATO goes, no, yes, there's core debt and penalty interest. You enter into a repayment program to cover all of that debt. If you comply with the program till it's repaid in full, then at the end, we'll then consider remitting or reimbursing you some of those penalties and interest. So once you get to the end and you then pay, we may then give you some of that money back.
That's a standard response.
Okay.
So that's the ATO's line.
Yep.
It was their line previously.
Yep.
They changed a little bit during COVID. They were a little bit more lenient depending on who you got on the phones, or how the application was written. But what you're telling me is the standard line, but that's not what we do.
That's okay. Yeah.
So we will push for it at the beginning. So there's a number of different reasons to push for it at the beginning. One is it reduces the overall payments because you're reducing the overall debt and what can then be dealt with. But that is a different application that has to be absolutely pushed for. An example of that is we were working with a client in December that was a steel manufacturer. I don't know if any of you have dealt with steel, but it's gone up over 60% during the pandemic. It was stuck in the Suez Canal, it was stuck on the docks, they couldn't get it in. There's been new disasters that have happened with steel. This particular client had a debt of $4.5 million. Almost a bit over $500,000 of that was interest and penalties. When you talk about 4.5, you think, oh, $500,000, well, that's nothing. However, that's still a huge amount. We got rid of the $500,000 of interest and penalties before the payment plan. So we wiped all that. We then got them into a short-term payment plan where they actually didn't have to pay anything over the Christmas period because Christmas is such a nightmare, and then re-looked at a payment plan starting this year to build up and match the other thing that's going on with steel and building contracts is there's fixed fee contracts everywhere that are a nightmare. So it's giving them breathing space. But yeah, that's their standard line, but it's not how we would operate or what we would do and how our applications are worded. But that said as well, I'll just add in, other than an insolvency event, you can't get rid of core debt. So that's something that people talk about all the time. Again, I hear, but he told me that can happen. If you go through an insolvency event or a small business restructure is the only way to get rid of core debt.
Unless your lodgements aren't up to date and you get a lockdown DPN, in which case, yes, the company's not going to pay, but as a director, you will pay.
The other thing I just mentioned too with interest and penalties, we can also get that back from old debt. So we've done quite a few matters where it's all completely been repaid and they are now up to date. and they might have ongoing lodgements, and we've gone back sort of 8 and 10 years and done a detailed review of what interest and penalties had been paid over that period of time. And if there are the relevant criteria for an application, we can get all that back, that then gives them a credit.
So does anyone have any other questions?
Olga, can you talk about Dadio's action or approach to collecting DPN liabilities? And perhaps above and below $100,000, are they commercial? If someone has a DPN that's expired and reckons liable for, say, $100,000 in PAYG tax and, say, super for a company that's gone into liquidation, do you have experience in negotiating settlements with Dadio?
So that's what they won't. It's not about doing a deal.
Yeah, once the DPN's expired, even if you say, look,
so if it's core debt,
yeah,
there is no deal. So if it's core debt,
even the DPN, direct liability, but
yeah. So if it's core debt, the only way to then get rid of that, if it's core debt, would be a bankruptcy.
yeah.
However, what they will do is enter into negotiations for a payment plan,
Right.
and for a sustainable payment plan that needs cash flow, potentially long term, or what needs to happen. But it's not about a normal commercial creditor. It's not about ever just doing a deal. You could say to an officer or put an application to you blue in the face, well, you're either going to get $500 or nothing, and they say, oh, that's okay. Then it will just have to, like I said before, it has to go from my desk to legal. And we haven't obviously seen it in the last 2.5 years, but prior to that, it's then whether they will proceed with a personal recovery action on that, but they won't do a deal on core debt.
So this is one of those occasions where, as lawyers, we have the reverse position from what Olga's been saying. Generally speaking, when we're negotiating with the ATO at the wind-up stage, it's really hard for us to negotiate anything with their lawyers except for a payment plan. We're not talking really about interest. Occasionally you can get, interest and penalties taken off at that stage, but Olga would have far more success in persuading the teams that she deals with to deal with it that way than we would as their lawyers. In the personal bankruptcy space, we, on rare occasions, can get core debt reduced. Not a lot, but I have had instances where at the creditors petition stage in the federal court, when you're speaking to the lawyers, there can be a bit of movement on the deal to be done. It's not a lot, it's rare, you've got to have a really good story to tell them, but where there are exceptional circumstances, they will on occasion enter into a payment arrangement, reduce the debt, and agree to dismiss the petition. But
that would only be after also court proceedings have been issued.
Correct,
That would never ever happen before it got into that, what I would sort of say the insolvency space, because those proceedings are already on foot and already being negotiated, but otherwise they won't.
Yeah. And in particular, if you've got a property or something and it's clear that you do have the assets to meet it, they probably won't negotiate with you. They'll want the whole amount paid in order for the bankruptcy to go away.
Very, very process driven.
But again, I sort of call them the corporate police in a way, because they're not really interested in the dollars. The argument that they generally put to the court is, well, there's a public benefit to insolvent companies or insolvent people being subjected to a liquidator or a bankruptcy trustee.
It's not by bankrupting and winding up all the companies, you get compliance by the rest of the population. So, yeah.
Just quickly, do they take illness into account?
For core debt or interest and penalties?
If one of the directors is ill or...
Not for core debt.